And now I would like to introduce today's speakers. Brooke McKeever is a member of the Labor and Employment team whose practice focuses in the area of employee benefits and compensation. Brooke's experience as both an in-house counsel in a multinational corporation and in private practice informs the practical solutions she provides to meet the business objectives of her clients. Brooke has advised both public and private companies with respect to compensation and benefit matters in connection with mergers, acquisitions, public offerings, and other corporate transactions. Michael Weber is a member of the firm's Employee Benefits Practice Group with almost 20 years experience as in-house counsel with 2 nationally recognized trustees and plan record keepers. Mike's clients greatly benefit from his deep understanding of how and where legal decisions intersect with business objectives. Serving clients in both an advisory and counseling capacity, Mike assists with the design, implementation, administration, and termination of employer plans. Last, John Barlament serves as the chair of the firm's Health and Welfare team, which is a part of the Employee Benefits team. John represents employers, third-party administrators, fiduciaries, brokers, and benefit consultants in all aspects of employee benefits law, with an emphasis on health and welfare plan matters. These matters include health care reform questions, such as Affordable Care Act, American Health Care Act, ERISA, COBRA, and mental health parity. He is an author of 2 of the country's leading employee benefit manuals, HIPAA Portability, Privacy and Security, as well as Consumer-Driven Healthcare, and is a frequent national speaker on these matters. And now I'll turn it over to the speakers and Brooke McKeever. Thanks.
Hello, thank you all for coming today. We have a number of very interesting employee benefits topics to talk about. I will start off talking about recent benefit case law and its potential impact on plan drafting, and then Mike and John will follow up on some interesting topics about defined contribution plans and health and welfare changes for this year. So to start, there have recently been a number of benefits-related cases that address certain provisions dealing with anti-assignment provisions, mandatory arbitration and class action waivers, and venue selection provisions and how they play out in employee benefit plans, and whether those kind of provisions are in fact enforceable with such plans under ERISA. So I'll go through each of these in turn and just describe how the court has been trending with respect to these types of provisions. The first would be anti-assignment provisions. So in 2018, 2 circuits addressed this issue, both of which upheld the anti-assignment clauses that are included in employee benefit plans that were governed by ERISA. By way of background, healthcare providers oftentimes will have individuals who receive their medical services assign their rights to benefits under their health plans to the providers so that the providers can go after the health plans directly to get reimbursement for those costs. The idea would be that the healthcare providers are in a better position than an individual to go after and litigate claims with a health plan. But in order to mitigate the risk of increased claims from these healthcare providers, plan sponsors have started including anti-assignment language into their plans so that only individuals who receive the services can and participate in the plan can go after them for claims of benefits. Now, the 2 cases that occurred this year, one in the Ninth Circuit and one in the Third Circuit, they both had similar circumstances where the patients tried to assign their rights under the benefit plans to the providers of the medical services. And when the medical providers went after the plans for reimbursement, the plan said that the assignment was void because it was prohibited under the terms of the plan document. The court agreed with the plan and upheld the anti-assignment provision. They noted that there's nothing in ERISA that prevents plan sponsors from freely negotiating anti-assignment clauses, And as such, courts will generally enforce the terms of an agreement that's been freely negotiated between parties. This is consistent with the rulings that most other circuits who've addressed this question have come to. Most have concluded that anti-assignment provisions in plan documents governed by ERISA are acceptable. One thing to note, though, is that anti-assignment provisions should be carefully drafted to specifically cover healthcare providers, because a general anti-assignment clause may not be acceptable. It needs to be very clear that it would cover all third parties, including medical care providers, and any type of assignment to a third party would be void. The next topic that was of interest was dealing with mandatory arbitration and class action waivers. The Supreme Court answered the question here on whether employees and employers could enter into an agreement that any disputes, any work-related disputes, would be resolved by one-on-one arbitration, which would mean that they would have to bring their claims individually and they couldn't participate in a class action lawsuit. The argument here was that these type of agreements would violate the National Labor Relations Act, because under that act, employees have the right to organize unions and bargain collectively. So previously there had been a circuit split as to whether entering into arbitration agreements that prevent class action lawsuits would violate federal labor law, in particular the National Labor Relations Act. And the Supreme Court resolved the circuit split by ruling that such agreements are in fact enforceable. The court held that even though the National Labor Relations Act does protect employees by allowing them to organize unions and collectively bargain, it says nothing about how disputes may be resolved. So there's nothing that prevents an employee and an employer from entering into agreement to resolve disputes on a one-on-one basis. So in general, mandatory arbitration policies that cover workplace-related claims are enforceable, even if they include a class action waiver. One thing to note, though, is that if the arbitration policy or agreement is going to cover plan-based ERISA claims or claims coming under an employee benefit plan that's governed by ERISA, the arbitration language would need to be included in the plan documents as well, so you'd need to carefully coordinate the two if there's a separate arbitration policy and the plan documents, so that it's very clear on how all disputes will be resolved. And the next interesting employee benefits related case dealt with venue selection, and that's basically dealing with which court a claim must be filed in. And a recent case in the Seventh Circuit upheld a venue selection provision in an employee benefit plan governed by ERISA. ERISA has specific venue provisions on where cases must be filed, which courts, and the question was whether an employer and an employee could pre-select which court that a case would be heard. So under ERISA's provision, a claim may be brought in a district court where the plan's administered, the breach or violation took place, or a defendant resides or may be found. Now, the Sixth Circuit, who first looked into whether or not venue selection would be permissible, found the ERISA language to be permissive, in that it's stating that the claim could be raised in one of any of these three places. And it doesn't necessarily preclude the employer from pre-selecting which one of those three that they want to have the case heard. And the Seventh Circuit agreed with the Sixth Circuit and ruled that there's nothing in ERISA that would prohibit a plan from contractually narrowing down the venue options, so long as they select a venue that's permissible under ERISA. They held that this was consistent with ERISA's policy goals because it would lead to more uniform interpretation of plan documents, and it would lower administrative costs, which would be beneficial for both participants and for the plan administrators. However, it's currently unclear whether other circuits will agree and follow suit with the venue selection cases, because there's been some discussion that these provisions may make it more difficult for participants to bring a claim against a plan, and it may cause an unfair burden for the participants. So in sum, in light of the recent case law dealing with anti-assignment provisions, mandatory arbitration, class waivers, and venue selection, these types of provisions may be a way for plan sponsors to limit their liability and put themselves in a better position if they have clear, well-drafted provisions that address these topics if litigation does eventually ensue. I think next up is Mike Weber. He's going to talk about hardship withdrawal rules.
Well, thank you, Brooke, and thanks for everyone attending. So the retirement plan world hasn't been a really active world in the last few months of 2018 here. So we'll talk just a little bit about what seems to be, from our experience, the most pressing item, which is hardship withdrawal. And then I'm going to move on to some topics, because this is a business law group gathering, about things that I think are really probably maybe of interest to you guys, specifically in dealing with employee benefit plans, retirement plans in particular, in this case from the buyer side. But quickly to talk about the hardcore benefits stuff here. Hardship withdrawal rules. This really arises out of the tax legislation, and it has finally come home to roost. It's going to be effective for plan years beginning on and after 2019. Excuse me, for plan years beginning on and after January 1, 2019. And importantly, for participants in retirement plans, in 401k plans, defined contribution plans, it expands substantially the sources that would be available for hardship distributions. Notably, some things like automatic contribution amounts, QACAs, we have them called here, QNEX and QMAX, which are employer contributions. But really, probably most noteworthy is that earnings on deferrals will now be available for hardship. Essentially, this opens up the hardship availability to pretty much almost every contribution type that's going to be in a 401k plan. And it's going to make record keeping a bit easier as well, because earnings on deferrals had always been required to not to be allowed for hardship, and now they're going to be going forward. A couple other things that really simplify the whole process. There is currently, in fact, a 6-month suspension when a hardship withdrawal is taken from pre-tax or Roth deferrals. So if I were to take a hardship withdrawal, let's say I had taken one in May of 2018, I couldn't start making deferrals or Roth contributions until 6 months later, let's say November of 2018. Under this change in the law, the 6-month suspension requirement goes away, and in fact, it's not even going to be allowed to be in a plan come 2020. But importantly, and one of the things that plan sponsors are going to need to think about, and presumably are starting to hear from their third-party administrators about already, is what you're doing for people who are currently in that suspension period. So someone, let's say, who took a hardship withdrawal in November of this year, the question being, do you continue to require them or forbid them from making deferrals or Roth contributions into 2019? You're allowed to do that. Or do you allow them to restart immediately come January 1? I think what we're going to see is most plans are going to allow people to recommence. Frankly, this has been more of a thorn in the side, I think, of TPAs and plan sponsors, because it involves additional record keeping, making sure, importantly, that you remember when the 6-month period has passed and make sure you get a new election from the participant. Do I do my own slides? There we go. Okay. Further on the hardship withdrawal changes. There's not going to be a requirement to take all loans before taking a hardship distribution. Why is this important? Well, the fact of the matter is taking loans probably puts most people who are already under hardship circumstances in an even worse position, because now they're already financially strapped. Now they have to take a loan that they probably don't have the wherewithal to repay, because if they did, they probably would have taken the loan anyways. This requirement, I think, finally people sort of realized wasn't a really sensible way to do it. And so, in fact, it comes out as part of the change in the law. There was a little glitch that got created by the change in the tax law, where for casualty losses, so this is like your house gets hit by a tornado, you would only be able to, under the way the law kind of glitchy wise did this, it changed things, is if, for example, in that case, unless the tornado came through and got declared a presidential emergency, you would no longer be able to take a hardship to get to borrow the money, or to take the money rather, to have your home repaired. The regulations do clarify that and are going to allow you to continue to take casualty losses in the more traditional sense. No need for there to be a presidential declaration that this is an emergency prior to being able to take that. Finally, this is the kind of one of the challenging things. The regulations that are out there are in fact only proposed at this point. We fully expect they'll go final sometime early in 2019. But due to that, it's a little tricky to amend plans. And we've been talking with third-party administrator record keepers to see what they're doing. And I think the most important part for plan sponsors in today's world is to get the decisions made, how they want to, if they want to implement these fully, we presume most will, and to get in contact with their plan TPAs to make sure they're ready to go on 1/1. There is some time to make an amendment to your plan, but even in that case, some TPAs have asked that plan sponsors make their amendments now. Again, the theoretical issue is that the regulations could change by the time they go final. That said, I have heard next to nothing, if anything, about people complaining about how the regulations implemented the statutory change. It just isn't much controversy here. So it's a pretty good chance the regulations will look nearly exactly the same in final form as they have in proposed form. So with all that exciting stuff on hardship, turn to a topic hopefully that may have a little bit more relevance on a day-to-day basis for those of you who are business lawyers. And again, I trying to think about some topics that I guess over the years from my time outside in-house at a TPA trustee record keeper, things that we kept seeing come up that maybe you want to consider in your deals or at least if nothing else, a little reminder to think about them. So with retirement plans, yeah, they effectively, I think, are kind of another asset of the business in the air quotes version of asset. The business doesn't really own it, but it's something the business has to make a decision about. And so depending on how you structure your deal, asset sale versus merger or stock sale, us benefits people can sometimes lump those second two together a little more quickly than I'm sure you would. You got to figure out what that plan's going to go. Is that plan in an asset deal? Is the plan going to go with the rest of the business over? In a merger or stock sale, chances are it's going to go, especially if you're taking the whole kit and caboodle of the business. The whole thing moves along. But by contrast, in a merger or stock sale situation where, say, your client is acquiring a subsidiary or a part of another business, the stock of a part of a business, it's not a guarantee that plan is going to move along with it. The plan may be held at the sponsor level, at the parent level, in fact, at the seller level, and your client or your target here is only a participating employer in it. So again, some things to think about there is as it goes. And why do we care? Plans carry with them baggage, right? So if a plan hasn't been handled right previously before the acquisition, you may take that baggage on. And what does that baggage mean? It means going to the IRS or Department of Labor, and sometimes paying them off. It sometimes means putting significant contributions into the plan. So it's something to think about when you're structuring your deal. Even if you do end up taking the plan, the next thing to think about really as part of this whole thing is once you take that plan with you, what are you going to do with it post-close? Are you going to keep it separately sitting out there as a separate entity in the newly formed group of companies, or are you going to try to merge it into your client's retirement plan? What's the right thing to do? Well, keeping it separate is going to cost more. You're going to have to do more annual reporting. You have to do an annual report on each one of them. Merging them together, well, it's the poison the well thing. You have a plan that has some problems. You merge it into your plan. You can sometimes poison the well. It's as the structuring has changed with the IRS over time, it's less dollar significant to poison the well, but it's something you just don't want to do. You don't want to get them together and have to try to go to the IRS and clean up a bigger mess. So what do we recommend? If you do even take the plan, before you merge it in, do some serious due diligence on it. And we've got some lists and things to think about that either we can work through with you or at least give you a heads up for things to start thinking about with your client. Finally, on this slide, if you don't want the plan, but the buyer is saying, or the seller rather is saying, we don't want it, we'd recommend you try to get it terminated before close. And that's particularly true if you're forced to take the plan, whether you're forced to take the plan as part of an asset deal or a merger or stock type transaction. Why do we want to terminate it before close? Well, from the IRS's perspective, if you terminate that plan before close, it's going to give you the chance to pay it out. And that's kind of the best thing to do if you're an acquirer in some ways. If you want to make sure your participants are set for retirement, maybe not the best thing. But from a keeping your life simple post-close, if you can get rid of that plan before you finish the acquisition, it generally is going to make your life simpler after the acquisition. Again, the trick here is you need to have your seller be willing to play ball and either keep the plan, or if they're going to send it over to you, declare it terminated before, in fact, you close the transaction. Final comment, I guess this is part two of transactions. Does a transaction trigger a right to a distribution? Something to think about. Depending where, the rule of thumb I use on this always is, where are the plan and the participants in the same organization when the dust settles? In other words, if the plan stays behind at the seller and you bought some chunk of it, either by assets or stock, generally at that point you can have a distribution for your participants. They can take a distribution from the seller's plan. If the plan in whole or part moves with you and the participant and the plan that covers them are in the same group afterwards, you're not going to be able to have a distribution typically. It's a relatively straightforward analysis, but a lot of times participants will think, oh, well, gee, we got sold here, we got acquired, I want my money. And they will probably be looking to your HR. The HR of their new company or of their old company that just got purchased. So I think that's all I really wanted to say on this slide. Number 3, standardized plans. So as you do your due diligence as an acquirer for your buyer here, you're going to want to get copies of all the plans that they have, their 401k plans and defined contribution plans, and frankly, all their other plans, health plans, defined benefit, whatever. Why do we care about standardized plans in particular? I flag this because it creates a technical glitch that, again, best to avoid if we can or get dealt with before the transaction closes. A standardized plan says this plan covers every member within the affiliated group of organizations. So if the plan moves with you to your acquirer, theoretically, and maybe that's all it is, you have to ask your IRS agents, theoretically, as soon as that transaction closes, you have a plan that doesn't just cover your acquired entity, but the whole rest of the organization too, all the affiliates, which is, of course, never what anyone intends. Can it be fixed? Sure. A lot of this stuff can be fixed, but there's a much easier way to do that, which is to amend that plan before it comes over as part of the transaction. So a standardized plan would be something we'd want to look at and help talk to you about in the transactional setting. So number 4 here, see if covered people and entities match the plan terms. So here's one of these situations where you'll want to probably do a little bit of due diligence on the topic if you can. And why is this a big ticket item? If your plan says it's covering employer or organizations A, B, and C, but in fact you're covering only A and B, or you're covering A, B, C, and D, there can be some significant dollars involved there in getting that fixed up. It's something that isn't entirely that difficult to do, because really it's a matter of getting your hands on the plan, seeing who it covers, and either maybe taking a look at the plan's audit, maybe doing a little bit of spot checking on a few participants to see. Especially spot checking on individuals who are not supposed to be covered by the plan, to make sure that they're not. It's something, again, better to do before you close the transaction, because if there's a problem, presumably you want to stick that to the seller, not take that on as your own and have to fix it after closing. Item 5 here, safe harbor notice issued and issued timely and accurately. So there are certain types of plans that are out there we refer to as safe harbor plans. And the idea of a safe harbor plan is you pass certain discrimination tests automatically. The comparison of the benefits go into highly compensated people roughly over $120,000 a year, and non-highly compensated people. A safe harbor plan says if an employer is willing to make a certain level of contribution to the plan, they can get, and that's vested or vested according to certain schedules, they get a pass on certain discrimination tests. It's a great thing if it works for your employer and your employer is willing to put a little bit of money up. So what's the issue? There's a notice requirement for it. And if the notices don't go out timely, there can be the assertion made that the safe harbor plan failed to be a safe harbor plan. What does that mean? You don't get the auto pass on your discrimination tests. What does that mean? Yeah. In turn, that can mean that your plan would have to be tested for certain discrimination problems. And if you've got a bunch of highly compensated people who've been putting in the maximum they're allowed to as deferrals or Roth contributions, they suddenly find out a couple unhappy things. A, they may have to get a lot of that money back. If it's been going on for some period of time, the safe harbor notices haven't been done right, but they think they've been getting the automatic pass, that test may very well fail, and again, which would cause them to get the refunds. But there also might be an obligation to make a corrective contribution from the IRS's perspective. Again, depending on the number of years, if the safe harbor notice hasn't been going out and going out timely, the dollars can add up. It's something, again, you'd want to have stuck to your seller, I think, as opposed to having to pick it up and fix it yourself when the dust settles. Excuse me. So, testing. A couple of things on testing. So we were talking about discrimination issues. Testing, every year, these type of plans are routinely go through some mostly mathematical tests that are often done by a third-party administrator or record keeper, and they're pretty good at what they do. The issue, of course, here is that you need to make sure that they've been getting the information they need. The record keepers need to know who is in the affiliated group of organizations. If they don't know that, they can't perform an accurate test, right? Garbage in, garbage out. So they need to know on a particular plan, does the plan just cover this entity? And are there other entities in the affiliated group of businesses? If there are other entities in the affiliated groups of businesses, how have those been dealt with? Have they been considered properly in testing? Relatively straightforward question, but I wouldn't, from my experience, I wouldn't rely on a Form 5500. Form 5500 is the annual return for a retirement plan. And there's numbers on there that are supposed to support the testing to demonstrate to the IRS you passed it. I will tell you, I've seen far too many times where those 5500s whoever filled it out didn't realize there was another owner or another entity over here, completely ignored them in running the test. And if they had the information, maybe they would have passed, maybe they wouldn't. Point being is you really need to get your arms around that. Make sure that all the entities that are part of the group that you're buying or the part of are related to the part of an organization that you're buying have been properly considered, have been considered in testing, and have been properly considered to make sure that they pass all at the numbers they need to. This one came up recently in the last week. Remember, companies can be considered in an affiliate group even when there's an international parent. So often you'll see this, and you see it also in the venture capital type organizations, where there's just this feeling that, oh, these entities are really all by themselves. Well, that may be practically true when how they operate, the fact that they don't have any interaction with one another. But the fact of the matter is, when there's a common parent, it's something you at least need to be thinking about. And when when the common parent is a foreign company, it doesn't matter to the IRS. It doesn't matter to the testing. They are still considered within the same controlled group of organizations. So it's part of a know your client thing, right? You need to know your client's makeup and how they fit together to make sure that they've been properly taken into account. A good step in your due diligence here, check the Department of Labor website. This is actually a really easy thing to do if you got the organization's name and their EIN. See if they've been filing Form 5500s for their plan, and if they have a plan that covers, let's say, 100 people, that there's an audit there. The Department of Labor publishes all this stuff out there. It's really easy and really quick. If they haven't been doing that, you need to think about what needs to be done to get them back into compliance. Now, the Department of Labor does offer a program called the Delinquent Filer Voluntary Compliance Program. And what it does is it allows you to pay really in corporate transactional terms, a slap on the wrist amount of money, and file your prior year's Form 5500, even though they're late. That's not the problem. That's not the big money. And it really, and actually, what it really comes down to is the idea of going back and doing a Form 5500, and imagine trying to do annual reporting on an organization for the last 10 years when you haven't been doing it. Gathering the data, worse yet, if you're over 100 people, getting someone to look at it and say, looks good. The time involved, if you can even get the data, can be rather daunting. So it's something to think about and try to figure out if there haven't been annual reports being filed timely, what can be done, what should be done, and whose responsibility is that going to be? Is that something that you can leave with the seller to get to the finish line? Or otherwise, is that something you can get protected against the time and money you're going to spend cleaning that all up? Two more last top tens in my book here. This is a rather nit one, but it actually can make a big difference. Does the definition of compensation in the plan include bonuses or exclude bonuses? I can't tell you how many times plan sponsors at practice does not reflect what's really going on with bonuses. Whether the plan excludes bonuses and they've been including them for plan purposes, or the worst version of it, the plan's definition includes bonuses and the plan sponsor simply has said, oh, well, no, that's not part of their pay. We don't get benefits on that. They don't get to defer on that. The second one's particularly costly, right? Because what happened, well, participants haven't been getting profit sharing on an amount that's supposed to be in the definition of comp. They haven't been allowed to make deferrals, which means the plan sponsor is going to have to kick in something there, not necessarily the full amount, but a chunk of that. They haven't been getting match on the deferrals they couldn't make, so the plan sponsor may have to come up with some money there. Again, it's the one thing I would say in the plan document that's probably worth taking a look at and checking with your plan sponsor's HR department, because for whatever reason, they have a lot of plan sponsors have struggled with this because, again, they don't look at bonuses as regular benefit eligible pay. Finally here, and again, another one from the files of real life, money purchase plans. Money purchase pension plans are pretty rare these days, right? You don't see a lot of them because the tax laws that used to make them beneficial have largely been changed, so they don't really have a lot of self-standing value anymore in most cases for money purchase pension plans. So what happens? Well, plan sponsors say, we don't really need these anymore, so they want to freeze it or merge it into their 401k plan or just plain get rid of it, which is great and admirable and understanding. They want to try to save some money. There's a little trick with money purchase pension plans that needs to be always checked on, and that's when you're going to stop and accruing under them, stop making benefit contributions for the year, you need to give what's called a 204H notice. Now, this is about the simplest notice in the world. It tells you what you used to get, what you're going to get, going to be zero mostly, and when it's effective. That's really about all there is to this notice. And it needs to go out between 30 and 45 days ahead of time, typically, of the change in the accrual. So it's really an easy notice. My gosh, it's so easy. But if you don't do it, the penalties are way out of line. For not doing the notice timely, the penalty is $100 per day per participant who didn't receive the notice. Up to a cap, not a very nice cap. $500,000 is the cap for failing to give the notice. And by the way, if all in, and that's if you actually tried to give the notice and maybe you just sort of screwed it up. If you didn't even try, like if most participants didn't get most of the information, is essentially how the regulation reads. It can be such that even though you tried to terminate or freeze the plan, you didn't give the notice, it's possible that the accruals continue. So what does that mean? An employer is facing going back and putting money in as if they had never frozen the plan in the first place. Again, the classic foot across, mile deep kind of problem. If you find out and can find out that your target used to have a money purchase pension plan, make sure you do a little bit of due diligence on that. With that, I'm going to turn it over to John. So thank you for your time today. And John Bartleman.
All right. Well, thanks, Mike and Brooke. Thanks, everyone. I'm going to run through some health and welfare plan updates here quickly. Several different things to talk about. Let's start off with the Affordable Care Act, the ACA. Everyone always asks about that in terms of its current status. Current status is it's still out there. The Republican efforts to repeal and replace have largely been abandoned now. There was some talk a couple weeks ago from Senator Cruz of Texas saying, hey, let's try to, during this lame duck session, let's try to get everything repealed and replaced. Everyone else said, no, Ted, you're kind of crazy. We're not doing that. So that sort of died. So we're left with the ACA in place. And of course, with the Democrats controlling the House, we don't expect any repeal efforts. There could be maybe some changes, maybe bipartisan compromise could occur. I hesitate to even raise that because, of course, no bipartisan efforts have been made yet since this got enacted in 2010 to make any significant changes here. But with that being said, there are two unpopular bills or pieces of the ACA out there, which I'm going to mention right now. The employer shared responsibility rules. This is the pay or play rule where if you're a a large employer with at least 50 full-time employees, you have to offer good health insurance coverage or pay a penalty. It's not well liked by either Republicans or Democrats, and so I could see maybe some movement on that. As right now, it still exists, it's in place. Same thing with the Cadillac tax. Cadillac tax is a 40% excise tax on high-cost health plans. So if the health plan here at Quarles and Brady costs, say, $30,000 a year for family coverage, there's an indexed amount, which is currently set at $27,500, and Quarles and Brady would pay a 40% excise tax on the difference between $30,000 and $27,500. So a $2,500 difference, we would pay a $1,000 amount for everybody who's in that family plan. The intent is that this would encourage employers to try to drive down the value of the health plan, try to make them more cost effective. It's completely hated by everybody, Republicans and Democrats, but it's a funding vehicle. And so it's possible that it could go away. What has been happening is they've been kicking this can down the road. It was supposed to take effect, I think, in 2016, then 2018, then 2020. Now it's up to 2022. I joke that I'll go my whole professional career and it'll never actually take effect. It's going to get these 2-year delays here. So we'll see where that goes. But there could be some changes there. There is one interesting lawsuit, Texas versus the U.S., where 20 states are suing, saying that because the individual mandate has been repealed, which says that all individuals in the country have to have health insurance, that is now going away. Because that has gone away, the whole Affordable Care Act should be taken out. It should be nullified. It's being heard by a Republican judge, a federal judge down in Texas. No opinion yet, even though he heard it a while ago. So we'll see where that goes. I think it's sort of a weak argument to say that because one paragraph out of a 1,000-page bill got taken out, that the whole other 999 pages disappear. But that's the argument, at least. So we'll see where that one goes. I would expect an opinion on it soon. Association health plans. I wanted to spend just a couple minutes on this because there's been some new regulations over the summer and some interest from clients about this. Association health plans, or AHPs, are a situation where smaller employers usually can band together to obtain health insurance coverage. And it has some historical roots after ERISA got enacted in 1974. There were a number of kind of fraudulent association health plans that came together. Marketers put them together and said, hey, let's have a Chamber of Commerce plan. Everybody in the city of Milwaukee participate in this plan, all you employers. And then they sucked out the money from the plan, all these employer contributions, and then went bankrupt, basically. And so all these providers and all these plan participants had amounts which weren't really getting paid. So Congress stepped in because states couldn't really regulate it due to ERISA preemption, said, hey, wait a minute, you can have these, but they have to jump through the MEWA rules. We're creating brand new multiple employer welfare arrangement rules, which enable states to kind of regulate these association health plans. Many states took advantage of these new rules, did in fact regulate them. Some of them just flat out prohibited MEWAs and said you can't have a MEWA at all here in this particular state. Others were okay with it, especially if it was fully insured. And at the same time, too, there had been another alternative to kind of avoid some of these more stringent rules if you had a bona fide association of employers. So if a bunch of employers all got together and they all had kind of a common business purpose, it could be viewed as one big plan with the association kind of being the driving force as opposed to a whole bunch of smaller little plans. Lots of different requirements that I note here on the slide in terms of what you had to do, what are the hoops you had to jump through in order to have them exist. DOL, when they apply those facts, those different factors to real-world situations, very stingy in terms of how often they'll view a true association to have existed. Wisconsin auto and truck dealers have one from years ago. There was a recent Minnesota farm co-op that got approved, but in general, DOL is kind of stringent in terms of finding a true association as existing. Flash forward here to today. President Trump late last year, issued an executive order saying, hey, I like association health plans, U.S. Department of Labor, DOL, why don't you come out with new rules that will make association health plans easier? DOL said, okay, sounds good. And so they came out with some proposed regs and then some final regs that make it easier for, again, usually smaller employers to kind of band together to obtain health insurance. Why do small employers want to do that? in the middle of the slide here, may avoid state and federal coverage mandates. This is a big one. A lot of states, for some reason, including Wisconsin, put more coverage requirements on smaller, fully insured policies than they do on larger, fully insured policies. They just have to cover richer benefits. So the smaller employers don't like that. They say, boy, if we were larger, we could avoid some of these state mandates. And so this enables them to kind of band together under these new rules, become larger, be viewed as being a bigger entity, and avoid some of those mandates, which drives down the cost of health insurance. So that's sort of the main attraction here. Under these new rules, you can follow the new rules, you can follow the old rules. There's various effective dates down at the bottom there. New rules are a little bit easier. There's a commonality of interest test where the employers have to be in the same trade, industry, line of business, or profession, or, and this is an important one here, each employer has a principal place of business in the same region that doesn't exceed the boundaries of a single state or metropolitan area. What does that mean in plain English? It means that you can have like a Chamber of Commerce plan. So, each city's Chamber of Commerce can say, hey, we're going to start up a plan as long as you exist here in the Milwaukee area or in the Phoenix area or Madison or Chicago, whatever it is, you can have your own plan. And it doesn't matter if you're covering plumbers along with, computer people. You can all be together just because you happen to be located in the same geographic area. And again, couldn't do that under the old rules. New rules, more flexible, does allow for that to happen. There are some requirements, though. You have to have a formal organizational structure. You can't be controlled by a health insurance issuer. Some non-discrimination rules apply, so you can't say to a particular group, Joe's Plumbing, you can't join us because you look particularly unhealthy, or you've had some bad claims experience, you're out. So there are some non-discrimination rules that apply too. State laws, I think, are going to be the big obstacle. When these rules first came out, we got a lot of phone calls from insurance brokers saying, hey, this looks fantastic. We've wanted to do this. We wanted to band together our smaller employers and kind of build them up. Can we use these to avoid the MIWA rules and therefore all the state law regulation? And the answer is no. States can still regulate these. Some states have come out, that more the Democratic-leaning states have come out and said, you know what, we don't like these new rules. We're not going to support them. We're not going to be behind them. Some of the Republican-leaning states have said, wow, this is a Trump initiative. We love it. We're going to be fully behind it. So there's a little bit of politics going on here, too, in terms of how states will approach it. Wisconsin has been somewhat silent on it. There was the insurance commissioner who made some verbal statements sort of in favor of them, but we'll see where it goes. With that, let's jump ahead to a slightly different topic here. And this is brand new, account-based plans. So in addition to, so employers are always looking for, again, creative ways to kind of drive down the cost of health insurance, right? Again, looking at association health plans, trying to band together, get better rates. Another concept that some employers have used in the past is, hey, let's get rid of our group health plan for our employees, but we're going to put money into a health reimbursement arrangement. We'll stick $5,000 or $10,000 into an HRA every year, and then you employees, you go out and shop for your own individual policy. It caps my liability at a set dollar amount. I'm the employer. I know exactly what my cost is. There's no cost overrun, and you go out and shop for however you want to shop for your health insurance. That has some legal issues with it in terms of some non-discrimination issues, and then the nail in the coffin for that kind of arrangement was under the Affordable Care Act. The Affordable Care Act says that health plans, including HRAs, can't have fixed dollar limits associated with them unless they're tied into another major medical plan. So if I'm the employer, I put $5,000 into my HRA, that's a hard dollar limit. It's not going to work unless that HRA is tied to a group health plan, to a major medical plan. And the agency said, and that individual policy, if you were to take the $5,000, go out and buy an individual policy, can't be integrated with the HRA. So basically the IRS said it doesn't work. You can't do this. You can't put $5,000 in, have the employee shop for their own coverage. Again, that was under the President Obama's administration. President Trump's administration said, let's do the opposite. Let's allow for this money to go in. Let's allow for people to shop. And so these new proposed regulations allow for a brand new term, individual coverage HRAs, ICRAs, I guess we call them, and then something else that they introduced as an accepted benefit HRA, where you could pay for various out-of-pocket medical expenses. And so these ICRAs, again, we'll see if this actually goes forward. We'll see if, in fact, they take place here. But the basic concept is exactly this. You put money in, the employer puts money in, employees go out and they shop in the individual market, and then they buy their own individual insurance policies. There are some restrictions on it, though. The employer can't offer a traditional group health plan to that same group of employees. So maybe you could say, okay, for our, let's use a law firm example. Maybe we want to pick on the secretaries, and so we're going to have the secretaries be in an ICRA. They have the burden of going out and shopping for their own health insurance coverage, while the partners, let's treat them lavishly, right? This is a good idea. I'm actually talking myself into it, actually, so that would be the basic concept here. Is again, you have to kind of partition it by groups. One of the issues that will come up, of course, is non-discrimination rules. Can you really, do that? And there's some, internal revenue code non-discrimination rules. So we'll see how all that plays out. That is one of the things which really isn't addressed in these regulations very well. Is can you really be truly discriminatory? But again, that's the new concept. I would expect that we'd see some final regulations maybe in 2019 with this, maybe taking effect in 2020. So it's not anything that's going to be available here in the immediate future. Accepted benefit HRAs, very similar to kind of a limited purpose HRA, where again, the employer puts money into it, and then the HRA can be used only for certain medical expenses, including premiums or COBRA contributions. So again, kind of a similar concept, but it's to be determined in terms of whether it'll actually be in effect. All right, I went through that kind of quickly because I wanted to get to the last couple slides here, which I think are more interesting. Wellness plans. Many employers, again, in an effort to control health plan costs, have implemented wellness programs. So we'll draw your blood, we'll figure out if you have high cholesterol, if your BMI is too high, whatever it is. And if you meet certain goals, then we'll give you a reduction in your health plan costs. That's a basic concept behind wellness plans. Wellness plans are subject to different rules out there. There's one set of rules from the IRS, Department of Labor, and HHS, U.S. Department of Health and Human Services. And those rules are pretty pro-employer. You can actually offer a premium discount of up to 50% of the total cost of coverage. So if the plan costs $20,000 for family coverage, your benefit, or the discount you can offer is $10,000, which really would catch, I think, many people's attention. If you throw out a $10,000 discount, people are really going to be paying attention to it. So very powerful there. For a long time, the other set of rules were kind of informal and unwritten. The EEOC has some rules in place where they've sort of threatened that these kinds of programs could violate the Americans with Disabilities Act, the ADA. They finally came out with regulations, I think, back in 2016. Those regulations didn't go up to 50%, they only went up to 30%, but they were challenged as being too pro-employer. The AARP, the Association of Retired People, sued over this and said, hey, we think these are too anti-employee. They actually won, and then a judge tossed out those regulations and said to the EEOC, you need to come up with new regulations. And we're giving you until December 31st, 2018 to come up with the new rules. EEOC said, we can't do that. We're not going to do anything by December 31st, 2018. So the judge said, okay, then all your regulations are gone. January 1, 2019, all those rules are gone, leaving every employer that has a wellness plan in limbo because now we don't have the certainty of the 30% number. Now, in theory, even a 1% premium differential could violate these ADA rules if you're gathering medical information of the employees. So employers are kind of back to where we were before 2016, where your wellness plan could be in violation of the ADA, even though the IRS, DOL, HHS said, this is great, we bless it, you're good. So it leaves the employers with kind of this quandary of, yeah, we've got three agencies saying fine, one saying we thought it was fine, and now our regs are gone. So leaves us in a little bit, I think, of a jumble here in terms of what to do. Most employers, I think, are willing to take the risk as a practical matter because we're really back to what the rules were in 2015, which weren't that bad. All right. And then the last one that I want to talk about here is cross-plan offsetting. And don't go to sleep. This sounds technical and arcane. Cross-plan offsetting, what the heck is that? But this is really interesting. So what it is this. Some TPAs have been using basically their relationship with one employer's health plan to benefit another employer or benefit the TPA themselves. What do I mean? Let's suppose John, a handsome young fellow, is a participant in the Quarles and Brady health plan, and he goes to an out-of-network provider, Provider Inc., and has a $1,000 charge for a service. And this is only for out-of-network charges, so it's kind of a small amount. About 97%, 98% of claims usually are in-network, so it's only out-of-network. Quarles sends $1,000 to the TPA, saying, okay, well, let's pay for John's services. TPA takes $1,000, sends it over to Provider Inc. Then TPA, a couple weeks later, determines that Provider Inc. should have charged only $700, not $1,000. So they're kind of retroactively saying, hey, we overpaid you. And the provider says, no, you didn't. We like our $300. We're going to keep our $300. We're not going to send it back to you. TPA writes a demand letter, but it's ignored. No one wants to sue over $300 or $3,000, $10,000. These amounts can be, of course, higher, but they sort of sit out there. What happens then? Let's take a different client of the TPA. So Sally is at Client Inc. And goes to Provider Inc. and has a $2,000 charge. So Sally goes to the same out-of-network provider that I went to, has a $2,000 charge. Client uses the same TPA, third-party administrator. The third-party administrator asks for $2,000 from the client, and the client sends it to the TPA. It says, yeah, this is Sally's charge. Let's send it over. You would think that the TPA would take the $2,000 and use it to pay Sally's bill, but they don't. They forward on $1,700 with a note saying, hey, we forgive you for the $300 debt owed with respect to John over in the Quarles and Brady health plan. A provider at that point has a choice. They can just say, okay, let's just ignore this. Let's just, let's write off the $300. Or alternatively, they can sue Sally, right? Because from their perspective, they've only been paid $1,700 out of the $2,000. The $300 note for giving them for $300 is meaningless. It's worthless to them because they think that they're owed the $300. And then, of course, they can turn around and sue Sally. Sally would be very surprised by that because she was told by her employer that, hey, the full $2,000 was paid. There's an explanation of benefits saying everything was paid. And so it creates kind of mass confusion and puts Sally at risk for John's debt. So this has been very controversial. There's a major case right now where the lower court ruled against a particular TPA, UHC, which is the largest insurer in the country. The Department of Labor weighed in and said that we think that this violates ERISA, at least under this particular fact pattern here. There have been some prior lawsuits where this has come up and has been asserted. We think it's unclear right now if the practice is unlawful. It's possible that you could design your plan to make this work, but the mixing of two different plans and the assets of two different plans just raises a lot of issues. So most folks are doing one of two things, either trying to opt out if possible. Some TPAs won't allow you to opt out. They didn't tell you that this was even in here, but you're stuck in here, or ensure that your contractual language offers adequate protection in terms of how clients have approached it. And with that, I think we're going to open up for questions, if there were any. No questions? I should have gone slower. I'm so sorry. Yeah. Any questions? Yeah, John.
Yeah, I have a question. If there's a sale of assets in purchasing a company and the seller is going to terminate their 401k, do then the parties try to help the participants roll that over into a new plan, I imagine?
Yeah, Mike, do you want to repeat it maybe?
You're right. Well, I guess so. If this is a transaction where they want to terminate the plan, and the seller would want to help the participants roll it over to an IRA. Did I understand that correctly?
Yeah, an IRA or some other way to do
it.
it.
I think that's pretty typically what they'll want the participants to do. That said, there tends to be what the Department of Labor refers to as leakage. They certainly could connect them with encourage them to roll it over. I think it gets a little more dicey where they start connecting them with specific entities that might accept the rollover for looking like maybe they're endorsing that particular entity. In the termination situation, they generally would want to encourage them to roll it over. In fact, they would probably be well suited to roll it over into their new employer's plan, assuming the new employer would accept it.
And if the participants have a right, or I guess get the distribution, or if they get a hardship withdrawal, that's still subject to ordinary income tax, but then not the 10% early withdrawal penalty. Is that kind of the issue?
Oh no, if they don't have another exception, even on a termination situation, they would be subject to it. So I'm 50 years old. If Quarles sold, bad example, but if the plan that I'm in was terminated and I got a distribution, I need to do something with that money. I need to roll it into either another employer's plan or an IRA. I don't have another exception to the penalty tax. I'd be fully hit on that. Termination creates a basis to make a distribution to somebody. A legal basis like hardship or disability or whatever. It doesn't create an exception to the 10% penalty tax.
Thanks.
Any other questions, either here in Milwaukee or in any of the other offices, or if you're looking at the webinar, if you want to type them in, if you have any questions there. Hearing none, seeing none. I think we're about at time here. So thank you for your time today.
Thanks.